I don't want to traverse any of the ground. And my lord, there have been very able voices that have, my lord, traversed that ground. So I will only supplement, my lord, on basically, and my lord, have a few words to say on justiciability and maintainability. Just a few words. My lord, my written submissions are essentially based on supplementing what I consider to be, my lord, respectfully, the most important aspect of this matter, which is Article 200. My lord, and I want to place before your lordship certain circumstances which I don't believe have been placed, which militate against a construction which says that the proviso is necessarily attached to the option in the substantive part of withholding assent. Number one, may I first take your lordship straight away? I know there is support, there's overwhelming support in the Constitutional Assembly debates. And I put this also, I'm not going to read it out. I put it in my written submissions. Dr. Ambedkar himself has emphasized that discretion is not contrary to discretion in the governor, is not contrary to responsible or responsive government. So discretion in the governor is mandated by the Constituent Assembly. The question is only one of scope. The question is only one of scope. And my lord, any remedy for its violation, discretion arbitrarily used. Now, my lord, if your lordship kindly turn to 200. So, apart from, my lord, the fact that the proviso to the substantive part has been invoked, my lord, by the two judgments which are not before your lordship, but my lord, which are germane to it, the state of Punjab and the state of Tamil Nadu. My lord, have used the proviso and used the proviso to replace the wording of the substantive part, which is not permissible. So, my lord, on a rule pertaining to construction of provisos, that if the words of the substantive part of the article are clear and express, you can't import words from a proviso which don't belong there. Now, my lord, the first part is undoubtedly discretionary. Nobody can deny that. The first part, which is the substantive part of Article 200, prior to the proviso, gives the governor three options. Now, that is necessarily discretionary. He can choose between option 1 and 2 and 3. Which of those options is up to him. In a cabinet system of government, that is more so. Because the legislative process in a cabinet system of government is that the bills are laid on the floor of the House by the government, particularly the minister in charge of the department to which the bill pertains. On the principle of collective responsibility, the entire cabinet has, my lord, a definite interest in seeing the successful passing of that bill. So, undoubtedly, when the bill is passed in the cabinet system, the aim will be, and if the matter was discretionary, the only discretion which will be available to the governor would be to give his assent to the bill passed. Which is why it would then render the other two options ocious, that of withholding or reference to the president. So the first part is necessarily discretionary. He can choose between these three options. Now, my lord, what does it mean? And my lord, that's the controversial part. What does it mean when it is said that he withholds assent? My lord, the same word is used in many Commonwealth jurisdictions where, my lord, the president or the governor is replaced by the sovereign, the monarch in that country. The same words are used. And my lord, the word withholding assent means, in effect, rejecting the bill. Withholding doesn't mean delaying. Withholding means rejection. So he has the option to assent, which the cabinet which introduces a bill would undoubtedly like him to do. He has the option of rejecting the bill outright. And the third option is, when he has a doubt regarding the constitutionality of the bill or the legislative competence thereof, he can reserve the bill for the consideration of the president because he perhaps thinks that the president is more qualified, since he's advised by the central government, to dispose of the issue where he has that doubt. So, my lord, these three are all discretionary. Now, my lord, we come to the troubling part, and my lord, the attachment of the proviso by two judgments of this court to the withholding of assent. It has been said that it's inextricably linked, that it attaches, the proviso attaches to the second option. Now, my lord, kindly see the wording, and for three reasons. Apart from a construction and use of a proviso to replace, well, a proviso can be an exception, but it can be an exception to the entire substantive part. You can't pick and choose and say that the proviso will qualify only one part of it, unless the words permit it. There must be the clearest intention that the proviso intends only to qualify a part of the substantive part. Otherwise, my lord, the proviso qualifies the entire, is an exception to the entire three parts. Now, my lord, please see the wording of the proviso. And my lord, there are three aspects of the proviso which militate against the construction of attachment. My lord, both courts use that word, so I'm using it. I know, my lord, those courts' judgments are not before your lordship, but my lord, since they have taken that view, and even the words pocket veto and absolute veto are used by that judgment, the Madras judgment. Now, my lord, the words used in the proviso, which are extremely important, is that first of all, the governor may. Now, my lord, as far as the substantive part is, he shall mandatorily choose between the three options, provided that the governor may. So, my lord, the first distinction which stands out is that the proviso is discretionary on the part of the governor. If at all it is the governor, my lord, if at all it is the governor who has to invoke the proviso. My lord, as per the Constituent Assembly debates, I may point out, Dr. Ambedkar has said that in a responsible government, giving advice to amend or redraft a bill does not conform to responsive government. It's best left to the government to do that. So, well, where does this proviso emanate from? Is it the governor who invokes the proviso, or is it the Council of Ministers on whose aid and advice he would otherwise act? But well, that's irrelevant to the construction, because even if it is the Council of Ministers who wants to invoke the proviso, the governor may do it. He may accept that suggestion of the council. He's not bound by it, because the word may is used and shall, and not shall. Now, the next words are, the next phrase in the proviso is as soon as possible. Now, my lord, as soon as possible is totally incompatible with the time. First of all, there is no timeline in the substantive proviso. I don't have to go with it. It has been repeated. My lord, there's a chart by the SG, by the Honorable Solicitor, about timelines where they are used. And my lord, I may just point out at this stage that where timelines are used in the Constitution, it is always timelines for compliance by the legislator or one wing of it. But where it is the high constitutional authority, on the ground that he is the high constitutional authority and he will act with constitutional statesmanship, timelines are not given to governors and presidents. Nor even for that matter, timelines are given to speakers, although there have been judgments of the courts, my lord, where the speaker. But timelines are never prescribed by the Constitution. It is done, as your lordships have seen in 198, for the legislature, particularly the Legislative Council, to speedily pass bills sent to them in the nature of money bills. So now that's where timelines come in. But for constitutional authorities, my lord, it is impermissible. My lord, it is almost disrespectful to put timelines. So, my lord, the second is in as soon as may be. And my lord, your lordships have been referred to the 1962 judgment, my very old judgment of Nambudri. Well, in Nambudri's case, on a construction of Article 196(5), it was held that even if both houses of the legislature, council and assembly, were to pass a bill But the presidential assent is not given, or the governor's assent is not given, or the presidential assent, in case he refers it to the president. The bill does not lapse on dissolution. They held that that was permissible. So 5 years.
Listening to that case, I think fourth or fifth time.
Yes, yes. So, but I'm saying it doesn't lapse only for one reason. I'm now using that judgment in the context of as soon as possible. It is, if you can pass a bill, at leisure almost, the assent of the governor does not have to be as soon as possible, certainly. It can languish for some time as well, including beyond the life of a given assembly. That was the facts of the Nambudri's case. Then, my lord, as soon as possible conflicts with the substantive part. So it can't attach. If withdrawal of assent, if withholding of assent requires no timeline, or there's no timeline mandated for it, as soon as possible is not a constitutional imperative for the government, for the governor. Well, the third part of the proviso is almost conclusive on this aspect of the matter, that is attaching. As soon as possible of what? As soon as possible, the next words are very important. After the presentation to him of the bill for assent. He has not yet exercised any of the three options in the substantive part of the article. It is as soon as possible after the presentation to him of the bill. He has not exercised, and particularly for the purposes of my argument, he has not exercised the withholding part at all. So this does not necessarily attach and can't attach to that option of the governor under the substantive part of withholding his assent. It cannot. By the very nature of things, it cannot. And my lord, this is corroborated by constitutional debates. It is corroborated by, as I've set it out in my written submissions where, and underlined the relevant portions. And also, my lord, by constitutional bench judgments of this court. I don't have to repeat them, my lord. Shamsher Singh, Beluri, I'm not going into the passages. Hex, and my lord, latest Nabam Arabia, where the power is discretionary under 200. And my lord, I take it when they say discretionary, it refers to every act required of the governor under Article 200. Not just a substantive part, even the proviso is discretionary. And my lord, I fortify that with the plain words of the proviso. One is may, the second is, my lord, it bears repetition. The second is as soon as possible. And the third is on presentation of the bill. These three take, my lord, the fulcrum of those two judgments, Punjab and Tamil Nadu, out of that attachment of the two, the proviso and withholding of assent. Withholding of assent, as your lordships have noted from the two judgments in Veluri and in Hext, causes the bill to fall through. It's the end of the matter. So, my lord, based on this, based on the construction of a proviso, based on the plain words, and my lord, based on the Constituent Assembly debates, all of which I have set out in my written submissions, it is not as if the proviso follows withholding of assent as cause to effect. That is the supplemental part I wanted to put in.
That's true.
Now, my lord, we come to the other questions. The first is of I adopt the arguments of the Honorable SG, Mr. Salve, and all the others who have said that justiciability does not arise in the case of certainly the president. Because, my lord, 201, the last word is for his consideration, not he shall assent. Those words are not used. And that is because, my lord, this is part of central state relationships. And the president represents the center because the governor represents, the governor is appointed by the president under 155 and the president is bound by the aid and advice of the Union of the Council of Ministers or the Union government. Now, my lord, if that is the case, what is the remedy in case this assent is wrongly withheld? My lord, there is no, certainly, my lord, one thing is for sure, that Article 32 petitions are not the remedy, because Article 32 is strictly for enforcement of a fundamental right of a citizen. A dispute between a constitutional authority being the representative of the center of the state and the government of that state doesn't fall within the scope of an Article 32 petition. Well, there may be a remedy elsewhere in the Constitution. I'm not into that. But certainly a 32 petition does not lie.
You are not considering the 32 petition today.
So that what is the enforceability? So, my lord, what is the enforceability when there is any breach, either of time, either of delay or withholding assent altogether without ostensible reason? What is it? There is nothing else? My lord, there may be something in the Constitution, but my lord, I am not advancing that argument today. There may be some other provision which permits that, but my lord, I am not advancing that argument today.
Responsibility is this part and subordinate. Just this part.
So, my lord, having said that, as far as timelines are concerned, your lordships have heard enough, my lord. There is a judgment which says that it can spill over to post the dissolution of the assembly. My lord, 361 is a bar. So also, my lord, 145.3 is a bar on maintainability. It should have been referred to a larger bench. And all of the fact that the point was not taken up at that stage doesn't prevent the operation of that very mandatory provision that it should be put up before a 5-judge bench. And it was raised. One of the submissions said it wasn't even raised. One of the submissions said
We are not sitting in an appeal or that judgment.
Yeah.
We are only here to answer the questions of the. We are different to us.
But my lord, one of the applications of the other side talk about maintainability on the ground that
That issue is already closed.
closed.
That is already closed. We have said that we will decide that.
But I have to apologize to your lordship on the ground that I did not know that since I was not here. A fault entirely of mine. I take the blame.
The difficulty is that most of the councils come here for some times.
Yes.
They say that they will not repeat anything which is already argued. But they are not aware about what is already been argued. And
Yes.
the same things are again thrust on our mind.
My lord, with that, my lord, I've supplemented on 200 and on my other submissions are in the written sub. I am deeply obliged for the brief reply which I was allowed.
Fully, Mr. People who has been consistently present in the court. Though Mr. Solicitor claimed to follow him, Gopal Subramanian, Mr. Gopal Subramanian and Mr. Civil.
Required somewhere for, otherwise I have been here.
Largely, I have been here,
Yes, sir.
but Mr.
But, yes.
Mr. Civil and
They are
Mr. Civil,
continuous.
Mr. Civil,
Lordships are.
on one or two occasions with the leave of the court, but we see Mr. Subramanian not the same chair
Yes,
from morning to evening.
And same smile.
And glued on the chair from morning to evening.
My lord, if my absence is supposed to be a censure of a censure of me, my lord, I can only say in my defense, I had compelling reasons to go abroad and come back.
No, it's all like it.
And my lord, I told the solicitor I can only appear on Tuesday, and he was very kind to give me a little bit of time. I am obliged.
Just come out and go.
Yes, Mr. Naru, you are for which state now? Not for Maharashtra.